Hi, my name's Louise Merrill. I'm a senior solicitor in the employment team at Clarkslegal. This is the 5th podcast in Clarkslegal's TUPE in 10 podcast series and will focus on who transfers when a TUPE situation arises. We'll look at the meaning of employee under TUPE and the tests that apply in deciding if those employees transfer. So let's look at the meaning of employee under TUPE first. The definition of an employee under TUPE is broader than that usually used for other forms of employment protection such as unfair dismissal. It includes any individual who works for another person under a contract of service, apprenticeship or otherwise, except anyone providing services under a contract for services, i.e. in a genuine self-employed capacity. Determining whether an individual is an employee is by no means an easy task, and it's extremely fact-sensitive. Let's take a look at some categories of individuals and whether they satisfy the definition. Let's start with those who are likely to fall within the definition of employee under TUPE. Employees. Unsurprisingly, employees in the typical sense of the word will be employees for the purposes of TUPE. Identifying employees in most cases is straightforward, as they'll have a contract of employment and are recognised by the employer as being employees. However, there may be individuals who work under a different label, but in reality meet the legal test of being an employee. We won't go into the test for employment status in this podcast, but it's important just to flag up that it's the reality of the working relationship that matters here, not the label that the parties apply to it, and so employers need to think carefully about their workforce in determining who is an employee for this purpose. Apprentices. As we've seen from the definition, apprenticeships are expressly included. Workers. A worker is a category of individual created by employment legislation to plug the gap between employees and those who are genuinely self-employed. They don't possess the key features of an employment relationship, but they provide their personal services to the transferor under a contractual arrangement which has an element of certainty and frequency, and their work is subject to the transferor's control and supervision. Whilst the case law in this area is somewhat grey, it's generally accepted that workers will fall under the definition of employee. Workers here should not be confused with agency workers, who we'll talk about shortly. Directors. A directorship is a role distinct from the particular director's employment status. However, most executive directors, even if they're shareholders in the company, are likely to also be employees of the company, particularly if they're working under a service agreement and are receiving a salary. Such employed directors would therefore be covered by TUPE. Secondees provided by the transferor. Secondees are individuals employed by one party and supplied to another party for a particular purpose. Where a transferor seconds one of its employees to a third party, that individual could still fall within the definition of an employee under TUPE on the basis that they usually remain an employee of the transferor, even if they're working elsewhere for another party. So turning now to categories of individuals who are unlikely to meet the definition of employee under TUPE. Agency workers. Agency workers will not usually be employees under TUPE because there's no contract directly between the transferor and the agency worker. The agency worker usually only has a contract with the agency, which then supplies them to the transferor. Genuinely self-employed contractors. The genuinely self-employed are expressly excluded by TUPE. However, again, it's important to consider the reality of the relationship here and not the label given to it by the parties. Secondees provided by a third party to work for the transferor. Secondees provided by a third party to the transferor are usually employed by the third party, not the transferor. Therefore, they won't be considered to be an employee of the transferor under TUPE. Now, a tribunal may be prepared to look through complex contractual arrangements and find that the transferor is in fact the employer of the secondee if it considers that this better reflects the true nature of the employment relationship, but this is more of a risk in long-term or open-ended arrangements or for secondments that are set up more for tax and administrative reasons rather than to reflect a genuine secondment arrangement. Non-employed directors. We talked earlier about executive directors who have a directorship but also an employment contract. Now, in contrast, Non-executive directors are not usually employees of the business, as their role tends not to be involved in the day-to-day operation of the business. Non-executive directors are not usually, therefore, employees for the purposes of TUPE. In summary, who falls within the definition can be difficult to ascertain, particularly if you're the transferee and you have limited knowledge of the transferor's working arrangements. Transferees need to ensure that due diligence is carried out fully so that they're able to identify all individuals who may potentially meet the definition of employee and may potentially transfer to them under TUPE. Transferors also have duties with regard to informing and consulting its affected employees, and so it's important for transferors to identify who its employees are for this purpose. So now let's take a look at which of these employees will transfer under TUPE. Under TUPE, the contracts of employment of all employees of the transferor will automatically transfer to the transferee, provided all the following conditions are met. The employee is assigned to the undertaking or services being transferred. The employee is employed by the transferor immediately before the transfer, and the employee has not made a valid objection to the transfer of their employment. Let's look at each of these briefly. An employee must be assigned to the undertaking or services being transferred, and this excludes those temporarily assigned, which I'll touch on shortly. It's often assumed that the only relevant factor when determining assignment is the percentage of time the individual spends on a particular undertaking or service, with more than 50% being the threshold. However, that's not how a tribunal will approach the issue of assignment. It will look at all of the circumstances. This will include the amount of time spent in the relevant business or service, and so it's definitely a good place to start, but it will also include factors such as the terms of the employee's contract, showing what he or she can be required to do, the value given to different parts of their role, whether the employee can and has been redeployed into other parts of the business, and the allocation of cost of the employee's time to different parts of the business. In most cases, employees who are temporarily absent from the business, such as those on sick leave, will still be in scope to transfer, the relevant question being where would they be if they weren't absent. Conversely, employees who are only temporarily assigned to the transferring business or service will not transfer under TUPE. Whether assignment is temporary will be a question of fact, and the purpose and duration of the deployment and the intention of the parties will be relevant here. Next, the employee must be employed by the transferor immediately before the transfer. Employees who have left the business prior to the transfer would not transfer unless the sole and principal reason for the employee's dismissal is the transfer itself. In that situation, the rights and liabilities of the former employee transfer over to the transferee. Unfair dismissal in TUPE is something that will be covered later in this podcast series. Finally, if the employee has made a valid objection to the transfer, their employment will not go over to the transferee. Any employee in scope to transfer under TUPE may object to the transfer. If they object, their employment will terminate by law on the transfer date. It's neither a resignation nor a dismissal, and the employee will have no right to notice pay. There's no formal method for objecting. The employee should simply clearly communicate to the transferor or transferee that he or she doesn't wish to transfer. Typically, objections are communicated prior to the transfer. However, objections after the transfer can be valid in certain circumstances. Objecting employees are not entitled to any statutory or contractual compensation on termination unless they're claiming that they've objected and resigned in response to a repudiatory breach of contract, or the transfer will involve a substantial change to their working conditions to their material detriment. These claims will be covered when we talk about unfair dismissal later in this podcast series. In some circumstances, the transferor and transferee will agree that employees who are otherwise in scope to transfer will remain with the transferor. In some circumstances where certain conditions are met, this may result in the contract of employment not transferring under TUPE, but case law is not clear on this, and to be on the safe side, parties should ensure that such an agreement is accompanied by an objection and a clear offer of re-employment with the transferor. The employee must obviously consent to this approach. That brings us to the end of this podcast. I hope you found it helpful. The next podcast in the series will be focusing on what transfers under TUPE. For further information on this area, please contact me on the contact details provided on the slide. Thank you.